Issues that matter to you. The Leslie Roberts Show. News Talk Radio, CJAD 800.
Coming up a little later, the mother whose daughter was having an allergy attack to some nuts went to an ER, told, take your daughter to the pharmacy by a nurse. She will come on and tell her story. But right now, let's talk about the more than 8,000 court cases thrown out here in the province. We're talking about some serious offenses under the Highway Safety Code, such as dangerous driving, excessive speeding, or even cell phone use while driving. Thousands of Quebecers will not have to go to court to challenge those charges now. The Crown Prosecutor's Office confirming the cancellation of 8,578 tickets and charges. And the man who started it all, Avi Levy at Ticket911, joins us now. Good morning.
Good morning.
So this was kind of like the domino effect. You filed back in September 100 cases basically saying that this is because of the Jordan ruling, 18 months too long, and then it just kind of opened the floodgates, right?
Pretty much, yeah. We filed in September, and we were heard on Wednesday of this week, and the judge granted the 100 motions, and subsequently the DPCP came out and said that they were going to cancel 8,600 tickets that had the same problem. Because I guess they figured the cat was out of the bag, and at this point, they were going to be canceled anyways.
And I get the argument that it should be limited to 18 months, but then I sort of sit here and say, well, there are people who, could have been convicted of some serious offenses and should have ultimately paid the price. So it's a balancing act and an argument. I don't know whose side I'm on, Abby.
It is a balancing act, but I can give you an example. One of our clients had a ticket, and it took 4 years for him to get a court date. He didn't even remember what the ticket was for. He could not remember his defense. He could not remember anything of the story. So there has to be, and it is a delicate balancing act, but there has to be, a middle ground between what the charter says and the delays in which you can be tried. And it can't be forever. There's got to be a set date, and it's 18 months. And now the courts are hurrying up and, getting their stuff organized so that they can be heard in 18 months. So the DPCP canceled 8,600 tickets to get them out of the system, to unclog the system, so that the current tickets that are being given can be heard in a delay of 18 months.
Why the backlog?
Lots of tickets. I guess budget cuts, not enough employees. Who knows the real answer? The bottom line is that there was a lag, there was a backlog, and it created these tremendous delays, 2, 3, and 4 years, as I mentioned, and that's just not acceptable.
Now, I'm not going to suggest that people do this, but it sounds to me like if you challenge a ticket and just, you're a betting person, that if it goes beyond 18 months, you may get off and never have to see it.
After Wednesday's news, that would probably be a losing bet.
Okay.
Because there won't be many tickets that are going to come in after 18 months, since they now know what the outcome will be. So the courts are getting organized, and the courts are adapting themselves to be able to have the cases heard in 12 to 18 months. And they're doing a good job at it. It's working, it's happening, and I don't think you'll be seeing many of these. But this was sort of cleaning up some loose ends that were lingering, and cases that were lingering sometimes for years.
But how long before that backlog comes back?
That's a good question. We hope it doesn't come back, because if it does, a whole bunch of more cases will be dismissed. And if they get their affairs in order and they streamline the system, it shouldn't come back, hopefully, and we should all be heard in a reasonable delay, which will make the system work much better.
But wasn't it mission accomplished for you and the guys at Ticket911?
Sorry, say that again?
But you sort of said it, unfortunately, that these tickets weren't heard, as opposed to, hey, this is mission accomplished you basically have done your job here at Ticket911.
Oh, absolutely. I have done my job, and the clients are very satisfied, and we're very satisfied with the outcome, because it's the right outcome given the state of the law and what the Supreme Court has said. And we were quite surprised that afterwards the DPCP came out and canceled 8,600 tickets, but we understand why it was the right thing to do.
Is it true that if you challenge, in other words, you take the time and go to court, that either the officer won't show up and they'll throw it out, or at least the judge will reduce the fine and the number of demerit points and so on, generally in traffic tickets?
Unfortunately, that's not true. The police haven't showed up in many, many years because their report stands in lieu of their testimony. So the police do not show up unless it's a excessive speeding case or something that's worthwhile for them to show up. Otherwise, they'd be there all the time. And the judge will not be lenient just because you ask for it, because if you broke the law, then he has to apply the appropriate penalty, and there's no question of leniency in there.
Does the system work in favor of the person who is ticketed? In other words, I mean, never mind the tickets that are being thrown out. Is it hard to prove dangerous driving, excessive speeding, or cell phone use while driving in today's courts?
I think the system works in favor of the person that's prepared. If you're prepared and you have your arguments and you're ready and you know where you're going and you know what you're saying, things are going to go well. If you try to wing it, you're going to need a lot of luck.
Okay, let's take an example here. Dangerous driving. I would assume a police officer has to appear because they caught you to basically explain what he saw and why he gave you the ticket or the charge.
In certain cases, as I mentioned, he'll appear.
Yeah.
In other cases, he'll write a report, sometimes a detailed report with diagrams and whatnot explaining the scenario. And then the defendant would have to go and present his defense, and the defendant would be there in person and would explain. And sometimes that's helpful because the report can't be cross-examined. The defendant the defendant could explain and elaborate a little bit more, and that's usually what helps them.
Do we have a percentage of how many of these cases actually someone can win when they challenge it based on lack of evidence or whatever?
Going themselves or using our firm?
I know the answer for the latter. I'm just wondering, in generally, how often do these cases get thrown out, I guess, is the question.
I couldn't really give you statistics, but if you're well prepared and the burden of proof for a defendant is a reasonable doubt. Mm-hmm. So all you have to do as a defendant is raise a reasonable doubt in the judge's mind, whereas the prosecutor has to prove beyond a reasonable doubt that you committed the infraction. So the burden of proof is a little bit lighter for the defendant, and in this case, if he's well prepared and he can give good explanations, usually they'll get the benefit of the doubt and they'll be acquitted.
Do you find that judges are harsher on such charges as cell phone use while driving as opposed to being 30 kilometers over the speed limit?
Well, the judges know and understand the fact that a cell phone violation could end up killing someone.
Yeah.
So can a speeding ticket. But I mean, so they're going to be, how can I say, maybe less tolerant for cell phone type tickets because of the actual dangers involved and the impact on the society.
Right. Are you expecting challenges, or have you had some already for driving while high since pot has been legalized?
We've had one already that we've successfully defended, and we're expecting that there will be a lot more because my understanding is that they're doing roadblocks in the middle of the afternoon, at night, randomly to spot check. And I think that, they'll probably be stopping some people in the near future. So I think inevitably, with the whole population now allowed to consume cannabis, that, there'll be some cases where people are stopped.
It was dismissed based on what? Your case?
It was dismissed based on the fact that there was a reasonable doubt that was raised as to the ability of the individual to see if they were really impaired or not by cannabis. Because the problem is, unlike alcohol, you don't have a scientific test. You can't measure the amount of cannabis like you